Hello, everyone, and welcome to Uncivil Law. I hope you are, as always, having just the greatest of days, and I am your host, Uncivil Law, with another edition of Supreme Court React. We are here with the case of Kelly versus United States. This involves Bridgegate from Chris Christie's New Jersey, which you may remember from the last presidential campaign. So I'm going to read the facts of this case, and we are going to get started listening to the oral argument. This summary, of course, is from oyez.org, O-Y-E-Z, if you want to follow along. This case arises from a scandal that became known as Bridgegate. Defendant William Baroni and Bridget Kelly conspired to create major traffic jams in Fort Lee, New Jersey, after Fort Lee's mayor refused to endorse the 2013 re-election bid of then Governor Chris Christie. The defendants and others limited motorists access to the bridge, the world's busiest bridge, apparently, for 4 days during the first week of the Fort Lee school year, resulting in extensive traffic delays. In 2015, a grand jury indicted Baroni and Kelly for their roles in the scheme. Each was charged with 7 counts under federal law, including conspiracy to obtain by fraud, knowingly converting, which is stealing, or intentional misapplying property of an organization receiving federal benefits in violation of 18 U.S.C. 371. and substantive offenses underlying the conspiracy in 18 U.S.C. 666. A jury convicted the defendants on all the counts. On appeal, the U.S. Court of Appeals for the Third Circuit, where New Jersey is, affirms the convictions as to 4 of the 7 counts, including the 2 that are at issue here. So the Third Circuit reversed as to 3 counts, apparently, for some reason, but 4 remained. In support of its conclusion, the court reasoned that the defendants had defrauded the Port Authority of its property by citing a traffic study as the purpose for the lane closures rather than the real reason of political payback. Which brings us to the question: does a public official defraud the government of its property by advancing a public policy reason for an official decision that is not the subjective, real reason for making the decision? Interesting question. So we can go a couple different ways on this. First thing that comes to mind is police officers. When they stop people, we don't look at their subjective motivations. We don't look at their real reasons for stopping someone during a traffic stop. We simply ask if they had a valid reason. So that would be one way to go. And also, because this is federal law, it raises issue of federal encroachment or federal entanglement with state affairs. You know, this is one element of a state doing things to the same state. So it would be officials of that state defrauding itself. So it's a little bit different in that respect too. And the fact that it's federal raises complications with state rights, raises complications with 10th Amendment issues and other things. And of course here, the principal issue that's at point is normally in law, we don't really look to motive. We don't look to reasons why in people's heads they're doing something. We simply look to the mens rea, guilty mind, and we look to the act itself. So if they had one reason and not another, does that matter? Or do they have to submit the real reason? Interesting question. So we're going to listen to this case and we're going to see what it has to say. I have no opinion right now as to the outcome of this. I have an open mind. So we are going to hear from 3 lawyers today. We're going to hear from Jacob Roth for the petitioner. That would be the defendant Kelly. We're going to hear from Michael Levy for the respondent supporting the petitioner. That's the other guy's lawyer. And we're going to hear from the Deputy Solicitor General on behalf of the United States. So we get to hear from the 2 lawyers representing the 2 defendants and the U.S. government. So let us get started. And as always, I look forward to participating with you in chat. I look forward to your commentaries and what your thoughts are on this. So, should be educational for everyone. All right, and I have to adjust the desktop audio, so it might be a little quiet first, but let's see what happens. Let's get started.
We'll hear argument first this morning in case 18-1059, Kelly versus United States. Mr. Roth.
Mr. Chief Justice, and may it please the Court. Once again, the government is trying to use the open-ended federal fraud statutes to enforce honest government at the state and local levels. Its theory this time is that the defendants committed property fraud by reallocating 2 traffic lanes from one public road to another without disclosing their real political reason for doing so. This theory turns the integrity of every official action at every level of government into a potential federal fraud investigation. It ends runs McNally and Skilling by subsuming honest services fraud within property fraud, and by criminalizing ulterior motives even without bribes or kickbacks. It would effect a sweeping expansion of federal criminal jurisdiction into a particularly fraught area. This is not the law. This court in Cleveland held that regulatory authority is not property. So an official who induces a sovereign decision through deceit has not obtained property by fraud. Only when the official lies to divert state resources to private use has he stepped outside the regulatory realm and committed property fraud. This rule distinguishes property fraud from honest services fraud and from routine political conduct. Here, because the defendants simply reallocated the traffic lanes from one public use to another, the Port Authority at most was deprived of regulatory control, not property. And that's true regardless of whether, as the government now alleges, the defendants lacked the authority in some sense to order the realignment. Mr. Levy will explain why the government is wrong to say that, but it's ultimately legally irrelevant, because the fraud statutes do not prohibit lying to take unauthorized state action. They prohibit lying to obtain property. And that simply is not what occurred in this case.
Okay, so I like this start, what he's doing here. So he's comparing it to another statute on the books, this honest services fraud. And as the name suggests, it's where you're giving services not honestly. And he's saying, well, Congress has already delineated separate things for separate things, and we should treat them separately. We shouldn't commingle them. And so he's saying this is not deprivation of property, because they didn't lose any property. They didn't lose the bridge. They didn't lose even access to the right to control the bridge. They made a decision based on faulty information, but is that fraud? And it would be the analogy might be, in the most extreme case, let's suppose it's you or me, right? Let's suppose I'm approaching the government because I want a law passed, and I have certain representations I'm making to the government. This is not about affecting me personally, okay? So this is not like, I'm a lobbyist maybe, or I'm just a citizen who thinks a particular thing would be a good idea, okay? And so I approach my state legislature and I say to him, I want you to pass XYZ law, and I maybe misstate facts, or I misrepresent the facts, or I exaggerate the facts, or I don't mention certain facts that are not helpful to me. I only mention the facts that are helpful to my case, and I emphasize those facts. And, he says, well, that's horrible. And he goes forward and gets a law passed. And it turns out after the fact that, he says, well, I was tricked because he didn't tell me these things and he overemphasized here and blah, blah, blah. I don't think we would say that qualifies as fraud. I've induced my government official to do what I want based on some facts, but he should have looked into it himself, right? So there's an idea there at least. So what he's saying to me makes a lot of sense to me, that they didn't convert the government property into personal property, right? They didn't take something from the government and put it into their personal bank account. They didn't embezzle. They didn't take a kickback. They didn't get any money of any kind. They didn't enrich themselves through governmental means. They got the government to do something for political vendetta, but as we've discussed in other streams, normally when governments do something, politics is part of the equation, right? So if it was proper to do, the fact that you had a political reason to do so doesn't seem determinative to my mind. And he's pointing out that, that the Supreme Court has already constrained the statutes we're talking about here in these other cases, and this is trying to unconstrain this. So, he's saying we don't want to put everything a state does into this federal fraud box, because it could get completely out of control. So we need to constrict this statute down, and then my guys are not guilty of it because when properly interpreted, it doesn't apply to them. I like his argument. I think it's pretty reasonable. Let's listen on. Let's see what else we got going on. I don't think it's by any means a winning argument. I'm not sold, but it's a reasonable posture. Let's see what he's got to back the posture up. Can he make it better?
You said that if the resources were diverted to private use, then the prosecution would be okay. But why isn't it a private use to benefit defendants politically?
Your Honor, I'm trying to distinguish the use of the property from the motive for the decision. So here, the decision was to realign the lanes from one set of public drivers to another set of public drivers. Both are public uses of the lanes. Now, it's true, the alleged motive for that regulatory decision was improper. It was political, right? That's the allegation in the case. But that doesn't mean that the use of the lanes was private. It's not, Your Honor, the typical case in which the government has prosecuted property fraud against a public official is where the official lies to take property from the government for his own use. So, situation where you lie on your expense report. You say you incurred this expense for business reasons and you did not. In that situation, you're lying and you're taking the property away from the government for yourself. That is obtaining property. Here, what the defendants influenced through their deceit was the decision about the alignment of the lanes. And if there's anything that is regulatory in nature.
So, Mr. Roth, on that theory, would it or would it not make a difference if the defendants here, rather than doing everything that they did for a political reason, if they had done it to make their commutes easier or their families' commutes easier? So it wasn't anything about politics. It was their own personal interests. But they did exactly the same things. Is that covered or is that not covered on your theory?
On my theory, that is certainly not property fraud. The officials, even in that case, have not obtained property by fraud.
So you're not making just a distinction between private uses and public uses? Private purposes and public purposes, maybe.
I'm certainly not making a distinction between the type of purpose. What I am trying to distinguish is the use of the property. And is it a regulatory decision to realign the lanes for whatever purpose? Because if what we're concerned about is the integrity of the purpose behind the decision, that really sounds in honest services fraud, right? Because what we're concerned about is not the government being cheated out of property that it has or that it owns. What we're concerned about is the good faith of the official in making the decision.
That's it can be a hard line to draw. I mean, if the rerouting of the traffic is done for the commercial benefit of the individual in whatever way, that would be a violation, right? He's got a development or something. He's building a hotel in Fort Lee, and he wants the traffic redirected there or directed away from whichever, because he thinks it will increase business at his hotel.
Your Honor, if the court were to consider that as a kickback, then that would be honest services fraud. It would not be property fraud, because again, the decision there is a decision about allocating scarce public resources among public uses. Again, the concern in Your Honor's hypothetical is, well, was it a good reason? Was it to benefit the public or was it to benefit himself? And what this court said in Skilling is if you make the decision because you were paid a bribe or because you're going to be getting a kickback, that is a violation of your honest services, your duty to provide honest services to the public.
What we're doing here is interpreting a statute. And it's not quite clear to me how your argument fits into the language of this statute. So money is property, and money was lost. So how does this fit into the language of the mail fraud statute, the wire fraud statute?
So Your Honor is correct. The relevant word is property, and the second relevant word is obtain. And this court in Cleveland explained that when the government is making sovereign decisions in its capacity as sovereign, implicating its regulatory interests, that is not property within the meaning that Congress had when it enacted.
Was there a loss of money in Cleveland?
Well, there wasn't. It's not clear if there was loss of property. Certainly, I would say there was an official in that case who was processing the fraudulent application. And if he had not been given the fraudulent application to process, he would have been doing useful work for the agency. And maybe he would have gone home an hour earlier and been paid a little bit less. I don't think any of that would have mattered to the result in Cleveland. Because it's all of that.
Still, how does it fit in the statute? Is it that property isn't obtained when it is simply wasted? Is it a gloss on the word defraud?
I think it's two steps, Your Honor. The first step is to establish that the decision, the realignment, is not property, because that's control. That is regulatory power. The second step is to say, well, then what about the costs of implementing it? And I would say the costs of implementing that regulatory decision are part and parcel of it, and the scheme is not to obtain that property. The purpose of the scheme, the object of the scheme, is to effect this policy decision, this regulatory decision, in the way that the officials want.
So in the case of sending city snowplows to clear your own house first, or sending city maintenance people to paint your own house if you're a public official, I was under the impression that you thought that would be a crime. Is that right?
If you're sending the public employees to do private work, yes, absolutely. That's not regulatory. At that point, you're just taking the city property and using it for private use, which is not you're obtaining the property. I would distinguish
So
that,
even though both are diversions of city resources or state resources, whatever it is, it's just one is regulatory and one is not, because one involves personal benefit?
Personal use. Yes, Your Honor.
I think that's a line you can draw, right? Because, again, the idea of making choices is stuff the state has to do. The state has to make all kinds of decisions on all kinds of priorities, and they trade all kinds of things for all kinds of public reasons, all kinds of legitimate reasons. And, so to the extent that a state is saying, well, we are not going to put as many snowplows out, or we're going to snowplow this part first or that part first, because as part of our decision-making process, we felt that it's part of the collective good, then we would say, yeah, even though it's diverting state resources, no one has a problem because it's going to other state causes, right? Whereas if you say, well, I'm going to borrow the snow plow to plow my driveway, everyone has a massive problem because that's a private thing. So yeah, it kind of matters in the sense of the property interest. Where's that property going? And the one example, I'll give you even another example. Let's suppose you become governor of the state and you say, well, I want more funding for X because I had a family member who died of it. I want more research into that. Or I really think this is a pressing problem. I mean, politicians run on this, right? I want to put more funding behind X because this is a problem that needs our attention, right? And then they get it to be politicians, and then if they keep their word, they actually do it, right? So it's a little odd to say, what are we exactly saying here? like a governor or a state legislature can't have a personal preference. It's improper for a state legislature to say, when I'm choosing what kind of medical research our state will be funding, well, by the way, my family has a high rate of this, so I want to fund that more. They can't factor that into the analysis. That seems a little odd to me. So I buy the distinction he's making so far. I buy the distinction of, a public use for public use on the one hand, public use for private use on the other hand being distinguishable. So that, makes sense to my mind. Carry on.
Every regulatory decision diverts resources in some way. I mean, every time a public official makes a decision, there are implications for the bureaucracy and there are implications for public property. So there is diversion going on, and maybe the decision was made for a bad reason. And if it's a bad enough reason, maybe it's an honest services violation.
Is your theory that the word obtain is what does the work in response to Justice Kagan's hypothetical?
I think it's obtaining property together. I don't necessarily think it's one or the other. Cleveland focused on property. And what did Congress mean when it said property? And I think it said, we are concerned with cheating people out of their property rights. And you can do that with a government entity. You can certainly cheat the government out of its property. Pasquantino is the example of that, where the court said you owe taxes to the government, you lie to avoid paying your taxes, you've committed property fraud. The same, by the way, could occur in a Port Authority situation. You owe a toll and you lie to evade paying the toll, you have cheated the government out of property that it's owed. But if what you're doing is making a regulatory decision, like allocating public resources among public uses, and there's no question that the main line is a public use just as much as the special access roads are a public use of the property, that is not obtaining property.
Now, I can understand the distinction between a regulatory decision and the deprivation of property when the regulatory decision doesn't cause a loss of property. But when the regulatory decision causes a loss of property, I find it more difficult to see the distinction.
Well, Your Honor,
explain it to me.
Your Honor, I think that every regulatory decision is going to have some consequences for public employee time, for example, which is the species of property that the government has invoked. But in this case, let's take this case just as an example. What they focus on, the additional money that was spent, was the toll keeper. The toll keeper had to do an additional shift. But the toll keeper was doing her job of collecting tolls for the public. So the Port Authority was not deprived of her salary. She was earning her salary. The objection is, if this regulatory decision had not been made, we would not have had to hire that toll keeper for that work.
Right. Well, I'll try this one last time. Tell me how this fits in. When we write the opinion, if we were to write one in your favor, how would we explain your result within the language of the statute?
I think the court would say the statute prohibits schemes to obtain property when you are using deceit to influence a regulatory decision, to change a regulatory decision. That is not obtaining property. And then the corollary that's important is the costs of implementing a regulatory decision don't change the result.
I think I'll try mine once more, too, Mr. Roth. Why, when a public official says to a city maintenance worker, you should paint my house before you do anything else, why isn't that similarly an allocation of resources?
Because it's not the job of government.
I mean, it benefits me,
right.
but I get to send, whether it's painting or snow plows, you go plow my street first.
Right.
Why isn't that an allocation of city resources?
Let me try to clarify, because I think I may have led to some confusion. If you're plowing public roads and you say, I want to plow my street first or my neighborhood first, that is not obtaining property by fraud, because that is an allocation of resources to a public use. It's a public use that happens to benefit you, and maybe that was your motive, and that's very bad, but it's not obtaining property by fraud. If you instead trick the public employees not into plowing the public road, but into plowing your private driveway, which is not the job of the government, right? That's not what the government does. The government is concerned with public property and clearing public property. If you trick the employees into plowing your private driveway, then you have taken their services for your personal use, which is fundamentally different. That's no different from...
Yeah, I like this answer. I like this answer. I like this line of delineation that he's making, that it's like, well, you know, the roads that we're talking about at the moment are public roads. They belong to the government. And so I want you to plow these roads instead of these roads. Well, they're the government's roads. They all have to be plowed. Now, the reason I'm saying plow these roads first is because it happens to benefit me personally. But you're not being deprived of anything, because you had to plow the roads anyway because they're the government's roads and they have to be kept. So it's like, I would like you to do this first because it's a benefit to me. And I would say also, like, to the extent a politician would say, I want you to do this because it's a benefit to my constituents and they will be happy with me. If their neighborhood is plowed first, maybe they'll vote for me. You know, I can say, you know, vote for me, the true plow king. I got your roads paved, your roads plowed first. You know, so like the idea of it for public reasons, public benefit, even for political reasons that happen to incidentally favor you, versus converting the property, you know, that makes a difference. And you're tricking the government only into doing what they would have done, just doing it in a different order that happens to benefit you. And it's like, and it's a benefit to everyone in the common, because the thing that they're doing is for the common. So it doesn't qualify as fraud because there's nothing flowing to you in a tangible enough sense to qualify as fraud. Now, I like what he's saying this might qualify as honest services issue, but if it's an honest services issue, let's go analyze it under that statute. Let's not try to cram it into this statute. I'm assuming the honest services statute didn't apply because that statute appears, based on the argument, to require a monetary kickback, monetary incentive. So that statute didn't work either. So they're trying to cram it into here. And it's like, well, didn't qualify as honest services fraud because they didn't get a kickback. And it doesn't qualify as fraud because they didn't convert property. So they're not guilty of either statute. Yeah, it makes sense. I'm buying this. I am buying what you were selling. Continue on.
Saying, I worked overtime when you didn't. Please pay me, my hourly wage for the hour time that I didn't work.
And that difference is, just to go back to Justice Alito's question, where in the statute?
The difference is in the scheme to obtain property. That's where it is in the statute. And so you look at what is the object of the scheme. And if the object of the scheme is to influence a regulatory decision, it's not a scheme to obtain property. That just follows from Cleveland. Otherwise, every decision that public official makes is on the table, and the only thing that is separating...
I'm sorry. I thought the scheme was to make life difficult for Fort Lee. If that was the scheme, and you defrauded the use of government property to accomplish your goal, why is that any different than taking the maintenance worker to plow your road, your private street?
Your Honor, the difference is that here the alleged purpose, the alleged motive was what Your Honor said, right, to increase traffic.
That was the scheme.
Yeah, the scheme was to do that through a regulatory decision, right, by realigning the lanes from one public use to another public use. So what the objection is to the conduct here is an objection to the purpose, not the objective use of the property.
My
That's the
problem
difference.
is, I don't think I can see a headline that would say it's okay for officials to use government public money in a way that is plainly unauthorized, not just in its motives, but its in end use. And an official can and should never be liable for that. Our public officials now can use government resources for their private ends.
Right. Well, Your Honor,
not mixed motive, which is the interesting question here with the traffic study. and whether you have enough whether they have enough evidence that there wasn't a traffic study. But you're saying when what the government has said, you're not authorized to do it. There's a question about that.
Yeah.
And you didn't have even a mixed motive. You had only a personal motive.
So, Your Honor, I'll let Mr. Levy speak a little bit more length about unauthorized, because actually the government's theory throughout the case was that he did have the authority and that he abused his power by making the decision.
A much more difficult question.
Yeah.
Yes.
But what I will say is I'm not trying to suggest that this is okay. We don't want public officials acting for personal reasons. We don't want them acting necessarily for partisan or political reasons. But what I'm saying is the remedy for that is not the federal property fraud statutes. We have certainly political remedies that were very much had pretty substantial repercussions here. There may also be state law constraints on official abuses of authority. In fact, New Jersey has a statute called official misconduct that is specifically directed toward unauthorized decisions with bad purposes. That's not what the federal property fraud statute is concerned with. The federal property fraud statute is concerned with cheating the government out of its property rights. And that's just not what we have here. What we have here is an abuse of power, a political abuse of power, and that's, if anything, again, that sounds in honest services fraud, which this Court has limited, due to vagueness concerns, to bribes and kickbacks. Your Honor, if there are no further questions. Thank you.
Thank you, counsel.
Let me pause for a moment while I get a drink of water before we carry on. Make sure to stay well hydrated. Yeah, so far so good. So far so good. Right? So we're doing what good lawyers, at least in my humble opinion, or good judges should do. Right? We're looking to the specific charge that he was charged with, and we're asking the question if he's guilty of this charge and this charge alone. That's all we care about at the moment, because that's what he was charged with, right? And so we're saying, is he guilty of this statute? It has these elements. This is the sort of underpinning of it. And he's laying a very good case why. He said, well, maybe this would have been honest service fraud, but that's been limited. That doesn't apply. Maybe it's a violation of state law, and the state could have prosecuted it, but that's not the issue we're here with today. We're here with the federal issue, right? We're here with the federal prosecution for this. And you're trying to cram this into a statute that it doesn't belong. And I think his argument makes a lot of sense to me. It makes a lot of sense. It's like the statute only forbids taking property from the government. What property was taken? Who was it given to if it was taken, right? For the government not to have it means someone else did. Who else had it if not the government? You know? So whether this should be a violation of anything else, whether it should be a violation of state law, is not the issue that we're here to solve. We are here to solve a very specific question, like good lawyers. We're here to solve the question of whether or not they are guilty of the particular crimes that they were charged with or not. And so far, I think he's saying what he makes sense. Zafel says, I hate to admit it, but I agree with him. Well, Zafel, then you are being a good judge. Good judges do not always reach the results they want to reach. Judges who reach results they want to reach are bad judges. Judges apply the law. And the only question is, and particularly since this is a criminal statute, right? Since this is a criminal statutes are to be narrowly construed because they have criminal liabilities. So that means we read them in favor of the defendant when we're trying to read them. They're narrowly construed, not broadly construed. And so does this qualify? No, I don't think so. At least what he says. So far, I agree with him. Let's see what his co-counsel says. Again, I don't necessarily think I'm not sold yet, but so far I'm like, okay, everything he's saying, this sounds pretty plausible. So I'm interested to see what his co-counsel says, and then I'm interested to see what the U.S. government says. Maybe they have another argument, and we'll bounce it out. Let's see what we got carrying on.
Mr. Levy?
Mr. Chief Justice, and may it please the Court, a public official who is acting politically and not for personal gain does not commit fraud by lying about his reason for an official decision, if the decision was generally within his authority. The government disputed that below, but now urges that as the rule in this Court. That concession requires reversal. The government alleged and proved that Mr. Baroni was the co-head of the Port Authority, responsible for supervising all aspects of its operations. The government itself elicited that there was never any policy that precluded Mr. Baroni from using his plenary authority to alter a traffic pattern. For the government's rule to work, this Court should require an objectively clear lack of authority, something not even arguably shown here. Otherwise, any official who conceals his political motivation risks being convicted of fraud if a prosecutor or jury later disagrees about the scope of his authority. If the government's rule is to provide any limits, this case must lie beyond those limits. I'd like to begin by discussing what the government alleged, argued, and proved below about Mr. Baroni's authority before it decided in this Court that an official's authority is the line between guilt and innocence under the fraud statutes. In the district court, the government alleged in the indictment that Mr. Baroni was responsible for the general supervision of all aspects of Port Authority business, including the operations of its transportation facilities. From its main cooperating witness, Mr. Wildstein, the government elicited that exact statement precisely, ticking off one of the allegations from the indictment. It elicited from Mr. Wildstein that the title Deputy Executive Director was a misnomer, that within the Port Authority structure, the Deputy Executive Director and the Executive Director had a 50-50 split in terms of power sharing, that the Deputy Executive Director was not the number 2 position within the Port Authority. That's from the government's eliciting from its own cooperating witness. The government also...
The arrangement is always that there's a New York representative who's the executive director and the New Jersey representative who's the deputy. Is that right?
That was, at the time, the arrangement. It was always appointed by the governor of New Jersey for the deputy executive director and the governor of New York for the executive director. And it was understood within the agency by everyone. All the witnesses the government called testified that that was the arrangement. They called Mr. Baroni's successor, who testified that that was the arrangement, that the one did not report to the other.
This is a bi-state agency. Why would New Jersey agree to an arrangement like that, where its representative is always in the second seat, at least nominally? Just the big brother across the river? Is that the?
I don't know the answer to that, except that the structure within the Port Authority was that was not the case. So they, in fact, as it actually played out, didn't agree to play second fiddle. It was understood that within the Port Authority, the Deputy Executive Director had equal authority. The Vice Chairman testified about these parallel chains of command that were understood, particularly for decisions made within New Jersey. It was understood that would fall within the Deputy Executive Director's scope of authority.
I think one of the government's main arguments on the sufficiency of the evidence, which is fairly pro-government in this situation, was that Mr. Wildstein had to lie to the Port Authority employees about the executive director knowing about this lane change. If, in fact, the reality of the situation was that Mr. Baroni couldn't do this without the executive director's acquiescence or acceptance, doesn't that show his lack of authority? Why isn't that sufficient evidence?
So 2 things, Your Honor. First of all, I don't believe we're here on a sufficiency ground, and for reasons that we've argued on our reply brief. But even within that, we're not saying that the lie might not be a piece of evidence. But even the government concedes in this case that the lie does not show a lack of authority. The government concedes that an authorized official is permitted to lie to their subordinates. And so it cannot be that circularly that lie automatically establishes the lack of authority. Here, all of the evidence at trial was that Mr. Baroni had plenary authority over the operations of the Port Authority. Mr. Wildstein actually testified his first answer when he was asked, why did you come up with this traffic study? His first answer was for purposes of the media and for purposes of explaining it to local officials. When pressed by the government, he said also to give a reason to career officials. But the fact that he has to not that he has to, that he chooses to tell a lie to career officials to make this go over more smoothly in the same way that a public official wouldn't tell the world that they're doing something for a political reason.
Would you spend a moment on the traffic study?
Certainly, Your Honor. The government has conceded that if and again, this is new in this court, all of these concessions, that if Mr. Baroni had authority to order a traffic study, then he could do so even with the intention of causing traffic in Fort Lee. And they concede that he had the authority to order a traffic study. So all of that is conceded. What they say is he lied about the existence of a traffic study. And as we point out in our reply brief, there was no lie about the existence of a traffic study. There was no representation at all about the existence of a traffic study. Mr. Wildstein went to the bridge supervisors and told them, I would like to know what will happen, what the effect on traffic will be if we switch these 3 lanes. Please switch these 3 lanes, or maybe not with the please, and study the results, collect the numbers, and tell me what the results are. The only part of that is a representation is the first part. I would like to know my motivation is, my purpose is. And the government agrees that's not capable of being the lie for purposes of a fraud conviction, a money and property fraud conviction. The other 2 parts are an instruction. They were an instruction to do a traffic study, and the employees of the Port Authority did that. That's what the government spent a great deal of time at trial proving, is that money was spent on a traffic study that they say was illegitimate because nobody ever cared about the results. But the government agrees now that caring about the results is not an issue. They say the traffic study didn't exist, and that's just flatly contrary to what
Mr. Levy, is it your position that suppose Mr. Baroni had said, I'm giving you no reason at all. Or suppose Mr. Baroni had said, we're going to do a traffic study, but it's going to be a sham traffic study. Would he still have had authority?
Certainly the first one. He certainly had, at any point, the discretion to say, as somebody had done very early on in creating these 3 traffic lanes, they weren't required by anything, at any point in time could have said, I think they should have a 4th, or I think they should have only 2 or only 1, and that was fully within his authority. And as the government argued and proved this case below, that was their point. That was their summation, was he abused the authority he was entrusted with.
And the second, we're going to do a sham traffic study.
I think he can do that. I think as a functional matter, who knows what actually results from that. But yes, he has the authority to say, we're going to do a traffic study because I want to do this thing, and for public reasons, it's easier to do a traffic study.
And you said that this was not a sufficiency question. But what is it if it's not a sufficiency question? Because as I understand your arguments, you're not pointing to any instruction that was incorrect or to the rejection of an instruction that you offered. So how are we to look at this other than through a sufficiency lens?
Frankly, the most obvious way to do it is as a government forfeiture of the issue. The defendants in the district court said the line is authority, and if we were authorized, then that is a complete defense. And the government told the district court, do not give that instruction. And the district court said, I'm not giving that instruction because it is not a defense, and I don't want to confuse the jury into believing it is. Now, in this court, the government is saying, actually, it turns out the hinge between guilt and innocence is whether or not he was authorized, and we get the benefit of a sufficiency of the evidence deferential review. even though we told the district court that this issue didn't matter at all. The government has forfeited the opportunity to prove that Mr. Baroni lacked authority. We offered to have that fight in the district court, and they said it didn't matter. Now in this court should assume that there was no lack of authority.
Is there any reason to think that the jury actually made a finding about Baroni's authority?
No, there's no reason whatsoever. The district court was attempting to make sure that they didn't consider that to be relevant. Right? That was what we pressed, was that this is the relevant distinction, and the district court wanted to be sure that the jury did not believe that it would be a defense, and nothing in the jury instructions suggested that it would be a defense. Thank you.
Thank you, counsel.
So Midnight Rose 07 says, I'm not really sure I'm buying what this guy is selling. Well, Midnight Rose, at least for me, I'm having a little bit of difficulty determining what he's selling is more my problem. You know, the first guy's argument was pretty clear to me, right? We have a whole bunch of criminal statutes. My guys were charged with this statute. Here's the parameters of the statute. Here's why it doesn't read on what my guys did, right? It's not arguing the facts of what happened. It's a straight line, normal, legal argument, right? Not contesting what the jury did, just contesting the law. No problem. I understand this. This guy, I felt a little bit more muddled to me. What exactly is he arguing? Is he arguing the jury instruction or lack thereof? Is he arguing a factual element? Because that seemed to be like what Kagan thought maybe was going on. There was a factual element. We're talking about sufficiency. The jury didn't have enough to convict. So the issue's not the law was wrong. The issue is Kagan's asking, wait, are you saying the law's correct, but the jury just didn't have enough to convict? So that's a sufficiency argument, right? If you're saying, well, the jury just didn't have enough to convict, sufficiency. Is that the argument? Is it a factual argument? Is it a legal argument? It felt a lot more muddled. So I had a lot more trouble, at least to me, keeping track of exactly what he was selling. So it wasn't so much that I didn't buy it. I just didn't know what he was selling exactly. What are you talking about exactly? Whereas the first guy sounded a lot crisper to me. So I don't necessarily think it was bad. It just left me kind of confused a little bit. I'm not really, I don't really know what you're talking about. So it's like, I don't really know what you're talking about. So, yeah. And the other thing was like that the government made certain concessions. Was the argument that the government made certain concessions and they only made it now? And those concessions actually undid some of the stuff at trial. So they didn't give the instruction, but now the government says effectively they should have given the instruction. So now the instructions are effectively wrong, and therefore the jury verdict is not to be trusted. In which case, if that's the issue, we could vacate and send it back for a new trial. We could give a different jury instruction if that's the issue. If the issue is the government kept changing its position, and they've changed their position in such a way that like the jury didn't have the correct legal framework, then that makes more sense, right? So maybe it's not that the law was wrong. Maybe it's that the government's later concessions undid certain things that happened at trial that now make the verdict no longer reliable. So what we should do, therefore, is vacate the jury verdict and send it back for a new trial, maybe. Maybe that's what we should do. Is that the argument? I don't even know what the argument is 100%. So I'm not quite sure what he's arguing for, what his position is. It was very confused to me. So what's going on? So it felt like he was floundering around. He was essentially accusing the government of floundering around, but he was floundering all over the place too. It's like, what exactly are you arguing? So That's what I'm saying. So let's see what the U.S. government has to say about all this and see if they have some really strong points that will make us reconsider the first guy's argument or make us reconsider everything. Who knows? You know, the U.S. government can sell me. They can sell me. Show me why. Make an argument why the first guy was wrong. I'm willing to be convinced. Let's see what you got.
Mr. Fagan.
Thank you, Mr. Chief Justice, and may it please the Court. The defendants in this case committed fraud by telling a lie to take control over the physical access lanes to the George Washington Bridge and the employee resources necessary to realign them. Unless they lied about the existence of a Port Authority traffic study, none of them had the power to direct those resources and realign the lanes. Because they told that lie, those resources were answering to them, to their own private purposes, rather than to the public officials who were duly appointed to decide what those resources should be allocated to do. Their actions in this case were fraud in just the same way that it would be fraud for someone with no connection to the Port Authority to impersonate Port Authority supervisors and order Port Authority employees to realign Port Authority lanes. Or if we want to put this in the private context, for someone to usurp the authority by deception of a taxi cab company's dispatcher and order the cabs and the drivers to go wherever the fraudster pleases. They don't get a free pass simply because Baroni worked for the Port Authority when the evidence showed that he didn't have the power to direct these resources in this way without telling the lie. They don't get a free pass because they're hypothesizing that legitimate decision makers might, in theory, have decided to realign the lanes when the precise point of their scheme was to take these resources out of the legitimate decision makers' hands and put them into their own hands. And they don't get a free pass simply because their motive happened to be political. Let me start with the legal argument that was made by Kelly's counsel, which seems to be drawing a distinction between public uses and private uses, and I think there are two main problems with that. Actually, probably three. One is I don't see where a license for that is in the statute, and that gets me right to the second problem, which is that it seems to draw a distinction between fraud where the victim is a public entity and fraud where the victim is a private entity, and the Court rejected that distinction in Pasquantino. I don't know in the taxi cab hypothetical what it means to say that it's only fraud if those cabs then go to private use. We're talking about a private company in that context. And the third problem is, I don't know how a jury, I think some justices on this Court were grappling with this, I don't know how a jury decides the difference between a public and a private use.
How do you? I mean, you have two separate points, I think. One is your statement now, which I think is stronger than in your brief, that if you have authority and you work for a government, only if you say and tell them a lie, an untruth, then you don't have authority. My goodness. The Code of Federal Regulations, the rules of any department, the government is filled with rules. And there are numerous instances where a person might say something untrue about something related to a rule that gives him authority for that. That's enough to take. We're back to honest services. And that's also true of the second. If, in fact, there are two separate parts to the second. I might as well get both questions out. Is that fair? The one on authority is I don't know where that comes from. That if you have authority to do something in government, but you can't, where you lie about anything that you wouldn't without it, well, then you're in the property stealing statute. And the second problem with your second claim is if you don't have authority, but you put what you take to a public use. Now, either that is a conversion of property and a obtaining of property within the statute, or it isn't. If it is, I don't see how honest services fraud is not back in the statute, which has been ruled out since McNally. And if it isn't, I don't see how this case works.
Well, Your Honor, let me answer the second part of your question first, and then I'll try to get back to the first part. To answer the second part of your question, I don't, as I was saying, I don't think their distinction between private and public uses works, because that's not a distinction that the statute draws. It's not a distinction you could draw with
then
private entities.
Then my point was, why then? We're back to honest services. There is no deprivation of honest services that does not require somebody in the government to spend some time or use some paper or use a telephone in order to achieve that dishonest thing. All right, if you're going to count that as property, well, fine, you could do it, I guess, under some statute, but if you do it under this statute then prohibits the taking of dishonest services, exactly what the court has held it doesn't do.
So, Your Honor, if I might answer that, it'll take me a second to play this out, but I think it's a very important distinction. They are trying to lump a bunch of different kinds of frauds together and make them all sound as if they're the same. This case is about a very specific kind of fraud, commandeering fraud. It is when the defendant tries to take over property that is in the hands of the victim and manage it as if it is his own property. That's what they were doing with the lanes on the bridge and the employee resources. So, for example, if there's a snowplow sitting there and I take the keys to the snowplow and I drive off in the snowplow, everyone would agree that I've obtained the snowplow. If I instead put on one of those masks from the Mission Impossible TV show or the movie and I impersonate the boss of the snowplow driver and I tell the snowplow driver to drive around in the snowplow and do the exact same thing that I was going to do, I have obtained the snowplow and the driver's services by fraud. But not every fraudulent scheme and not every deceptive scheme works that way. Sometimes there are deceptive schemes in which somebody simply wants an agency to do something or wants a private victim to do something on his behalf. And then you have to look at what is actually the object of the scheme and how the scheme works to see if the agency is deprived of property.
But the basic difference between taking the snowplow is that the official has no authority to take the snowplow for his private uses. The official does have authority to regulate how lanes are used on the highway and say these are going to be used for Fort Lee, these aren't.
Well, first of all, Your Honor, Baroni did not have that authority in this case, and I can get to the evidence.
Disputed.
I can get to the evidence of that in a second. But also, I don't think that it's fair to call this a public use. What we would say is a public use is the use to which the legitimate supervisors of the Port Authority have decided to put the Port Authority's resources.
Okay, so what you're saying, your theory is that by the actions in this case, they have commandeered the lanes on the expressway?
Yes, Your Honor. They commandeered the lanes and the resources necessary to reallocate.
They're still being used for public purposes.
Your Honor, I'm not sure what they mean when they say they're being used for public purposes. So
if people want to use the highway to get to Fort Lee, they can. But they have nothing to do with the scheme at all.
So, Your Honor, I guess I would push back on this to this extent. If they decided to close the bridge, is that a public use or private use? If they decide that only Kelly can use that lane, is that a public use or a private use? If they decide that only red cars can go down that lane, is that public or private use?
Well, I'll answer his hypotheticals, at least to my mind. If they decide to close the bridge, is that a public use or a private use? Well, presumably it's a public use. There might be very legitimate reasons to close the bridge, and so I would suspect that would be qualified as a public use. If you decide only Kelly can use the lane, well, that would be private, right? Because it's just Kelly for him personally. If you decide only red cars can go down that lane, again, I'd say public use. First of all, a lot of cars are red, and there might be legitimate reasons, possibly, to filter lanes by the color of their car. Now, I can't think of any obvious reason off the top of my head, but if you had some studies that showed like the statistical distribution of colors of cars, and therefore by putting certain colors in certain lanes, it would have certain effects, or blah, blah, blah. I mean, that qualifies as a public use. Let's put all the red cars in the rightmost lane. I don't know. Is that a good idea? Could be. Seems like a public use, right? The public is probably going to be pretty irritated by these random rules, but it's a public use. I'm good. I'm not buying what this guy is selling. I'm not buying these guys' hypotheticals. What is he talking about with the snowplow thing? Like, okay, I take the keys. I've taken the snowplow. I've obtained the snowplow. Right. I've impersonated the manager. I get the guy to do it. Yeah, I've still obtained I've still obtained the snowplow because he's my agent for my personal use. I'm not really the government. I'm pretending to be. But if I'm actually the guy, if I'm actually the government, he works for me. And if I'm like, go plow this street and not this street, that seems okay. Or like, don't plow any streets. We've decided that plowing streets is bad now. We don't want to plow any streets as we watch the cars careen into the ditches or whatever. I don't know. It seems like public uses. So I don't know. This guy, I don't know what he's trying to sell me, but I'm not buying it. I am not buying it. And the problem is the reaching problem, right? This again, criminal statutes, right? Criminal statutes have to be narrowly construed. So we don't want to have breadth. We don't want to have breadth problems. We don't want to have a lot of uncertainties when it comes to criminal statutes. We want them to be nicely confined, so that at least the principle people can understand them. And it's like, you want to bring in all this stuff. It's like, no. You want to get to the fact. You want to get to the fact that because a clerk had to fill out a sheet of paper she wouldn't have otherwise filled out, that qualifies as deprivation of property. No, we're not going to allow you to do that. That was in a prior case. We're not going to let that fly. And so this isn't our services fraud. It's not taking of property. I love how the Solicitor General's like, I can't distinguish between private use and public use. Really? You can't distinguish that? Like, did members of the public still have the ability to use it? Or not on even terms? Let's carry on.
Any of those things. They said anybody. It was just a problem getting there, which was quite a problem, I grant you. Quite a problem. But they used it for cars going down. Well, snowplow. Hey, there's a law here. A rule. Treat every street alike. And you know what the snowplow operator did? He snowplowed the mayor's street first. Now, that is not a good thing to do. It is really undesirable, and maybe it should be a crime. But 30 years in prison? That, I'm not sure. And this statute has to do with property fraud and is taking the snowplow and putting it to the use of the public streets in violation of a rule, treating the mayor better. Is that a property crime?
Your Honor, in that law, in that hypothetical, that we would not say that is fraud. There is no lie. There's nothing material.
Oh, of course there is. Where are you going? I am going to 5th Street first, and then I will go to the grocery store at the street, and then and you know what he did? He went to the city councilman's street. All right? There's a lie. It's easy to make up cases that there's a lie in, and that's my problem. Same problem. We're back into honest services fraud, which is fraud and bad. And the question is, does this statute get it?
We are not in honest services fraud, Your Honor. First of all, the lie in your hypothetical was not a lie that was told to obtain property. It was just a lie about what he was going to do. But here's the reason we're not in honest services fraud.
They wouldn't have given it to him if they...
In the honest services fraud cases, in McNally, for example, there was no dispute that the defendants in McNally had the authority to decide who was going to insure the state of Kentucky.
Well, Mr. Fagan, this is what troubles me about your argument. Your argument is that if Baroni was authorized, he could not be convicted. Am I right?
If Baroni had the authority to do what he did, then he's not committing fraud,
all right.
even if he tells a lie.
Okay. And you say that takes care of a lot of these hypotheticals that seem that are disturbing to some people. You say, but the jury found that he was authorized, and there's sufficient evidence to support that finding.
The jury found he wasn't authorized.
I'm sorry. The jury found he was not authorized, and there's sufficient evidence, viewing the evidence in the light most favorable to the verdict, to support the finding. But I see no indication whatsoever, no reason to believe the jury made any such finding. I've read these jury instructions several times. There's nothing in there that would alert a jury a juror to the obligation to find that Baroni was unauthorized, unless I missed something.
Your Honor, let me say a couple things about that. One, they did not make an objection to the jury instructions properly either in the Court of Appeals. It's not part of the question.
No, I know
here.
that, but I've never seen a criminal case where we're asked to defer to a jury's finding on something that the jury didn't find. Putting aside the question of whether there's any evidence to show that he lacked authority.
So let me point you to a couple of places, and then let me talk a little bit about the evidence of lack of authority. First of all, there's the instruction that the Court of Appeals deemed adequate, and that's at page 875 of the Joint Appendix, which is the instruction on obtaining property, which the Court of Appeals deemed sufficient to notify the jury that when someone is acting on behalf of an organization, acting as the agent of that organization, he's not obtaining property when he exercises the authority that the agency has duly conferred on him. But even better than that is the materiality instruction from pages 875 to 876, which says that if you find that the representation that the lane and toll booth reductions was for the purpose of a traffic study was false, you must determine whether that representation was one that a reasonable person might have considered important in making his or her decision to commit Port Authority resources for that endeavor, including the services of Port Authority personnel.
What does that say about authority to
Your Honor,
reallocate the lanes?
If Baroni actually had the authority to reallocate the lanes for any reason or no
this
reason,
is not going to fly. No. This is not going to fly. I appreciate the effort, but this is not going to fly. Basically, what he is saying, in my humble opinion, is he's essentially saying that the jury instruction about finding this guy was unauthorized was implied by other jury instructions. It was implicit. They couldn't have done this, and this if they thought it was authorized. So, of course, the jury made a decision that he was unauthorized, even though it's not in the instructions, because it's implied by all these other instructions. No. We're not gonna hide the ball in a criminal case. If we want the jury to find something, we ask them to find something. And at least to my lawyer mind, I don't really think it's implied. Even if like I was willing to accept the premise that like implied instructions are somehow okay, I still wouldn't agree with him because I don't think it's implied. He's reaching as far as I'm concerned. I wouldn't read it and think it's implied the way it's been explained to me. You know, when I have a little bit of legal experience, so, you know, if I wouldn't do it, I'm guessing a jury probably wouldn't either. So, like, it's like, yeah. Oh my goodness. So, yeah, if he's authorized, even if it's a lie, he's not guilty. Maybe we should give the jury an instruction on this about whether or not he's authorized or not. That'd be helpful. And I'm not even 100% sure that being authorized or not is a factual question. Is that a question of fact, whether he's authorized or not? I'm not sure it's a question of fact. I mean, you could ask questions about certain sub-elements that would, like, is he X, Y, and Z? But the ultimate, is he authorized, seems more of a legal conclusion. So, I mean, someone has to consider it in the first instance. Carrying on.
Stated to this court that he did. I don't see how the jury could have found that the lies that they told were material.
Mr. Fagan, everybody has authority to spend or do their act on behalf of the agency. Anybody who does it for their own personal purposes is unauthorized. So it's meaningless to say, is he authorized or not? Did he have the authority to close the lanes under some circumstances?
Well, Your Honor, I don't...
Did he have authority to close the lanes on his own say?
He might have, Your Honor. What he didn't have was the authority...
Did you prove that he had limited authority? Where did you prove
We proved that he did not have the authority to close the lanes under these circumstances without telling the lie. And I can explain why if you'd like. When Wildstein first proposed the idea of realigning the lanes, Baroni's immediate response was to ask Wildstein how he was going to do that. Wildstein then came up with the idea that they would have a traffic cover story, the cover story of a traffic study. And he explained at the time to Kelly that one purpose of the traffic study cover story was in order to enlist the Port Authority officials that they would need in order to realign the lanes. He then had to lie to both the manager of the George Washington Bridge and the manager of tunnels, bridges, and terminals that the executive director was aware of this and apparently had tacitly approved of it, where, in fact, they were absolutely concealing it from the executive director.
By the way,
but that doesn't go to the question. That doesn't go to the question because, as I understand it, all the people that he just named are his subordinates, right? He's co-director of this bridge or whatever, and so like all the people he just named are his subordinates, and so you can lie to your subordinates because you're not like going up the chain, you're going down the chain. So like you're lying to them about what you're doing. So the only question is, can I do it? It goes back to the earlier question of like, what if I had no reason? What if I just said, do you know, guys, here's what we're doing now. We are closing the second lane of the bridge. And they say, why? And I say, because I'm your boss and I just told you to. How about that for a reason? I mean, like, they can't say no, right? So, like, he came up with a cover story so they'd feel all warm and fuzzy about it. But he could have just said, do it because I'm the boss and go forth into this world. And apparently he had the authority to do that, as far as I can tell. So, like, he lied to all these people, but it doesn't take away his authority to do it. So, and he wasn't doing it for any benefit to him at all, really. He was doing it as a political retribution, which is not a good reason. Like, it goes on his services, but that's been constrained and that's out. So it's like, I'm not buying the government's argument here, not given the statutes the way they're written. You know, make no mistake, I'm not saying that they're good. We're just being like good lawyers and interpreting a criminal statute, and we're interpreting them narrowly because we don't want to send someone to jail for something that they didn't do. Right? Whether it was good or not, whether he gets away with it, you know, in the end is not my immediate concern. My immediate concern is the statute. And, you know, I feel like at a bare minimum, you had to like make the jury aware of this argument on some level. So I'm not buying this.
If their expectations, there had been no slowing of traffic. And in fact, the lanes, on one lane, traffic remained the same or maybe improved. Would you still have a case here?
Yes, Your Honor. It's not about the effect of it, although the effect was catastrophic, and that was a reason why the prosecution was brought, because of the incredible danger in which they put the citizens and commuters of Fort Lee. But they would still have committed the same crime. And they were hiding it from the executive director. Wildstein testified directly that there were processes in place to use the Port Authority resources, and he didn't follow them. And when the executive director found out, he immediately canceled it, and he stated that the process had been, quote, subverted. Now, Baroni clearly had significant authority within the Port Authority organization. But when someone questions how they're going to do something, has no idea how he's going to do something, has to lie in order to accomplish it, has to lie that his boss has approved it, has to conceal it from his boss, and has to avoid every legitimate process the organization...
Isn't it often the case that somebody who has the authority to do something may lie about why the person is doing the thing, because if the real reason was exposed, there would be it would cause a furor. People would be angry, but that doesn't show the person doesn't have the authority to do it. A person hires his brother-in-law for a position. Why did you hire this particular person? Well, this person is the very best qualified person for this job, when the real reason is his wife wants him to do it. He doesn't want to say it. Does that show he didn't have the authority to fill this position?
No, Your Honor, but that's not the only piece of evidence we're relying on, and it's a different kind of lie. This isn't a lie about why they're doing it. This is a lie that Wildstein directly testified that they needed to tell in order to get the resources that they needed. It was clearly important to the George Washington Bridge manager and the manager of tunnels, bridges, and terminals that this was something the executive director knew about. Both the executive director and the vice chairman of the Port Authority Board of Commissioners testified that they would expect to be notified about something that was even an order of magnitude less disruptive than this was ever going to be, and they weren't notified. And
what do you do about this? This is the same, but I don't want to lose.
Matthew says, isn't it illegal to hire someone because they're your brother-in-law? In some circumstances, certainly, that would be nepotism, particularly for government-related works, but, not necessarily. They're family-owned businesses, right? So it's not inherently illegal to hire your own family. So it would depend on the circumstance. And if you wanted a cover reason for something, then okay. So, yeah, it might be illegal, but not necessarily.
What the question was in light of the instructions given. And
A. Hedinger says the boss thing seems pretty important here. Was the executive director his boss? As I understand the record from the first guy, and I'm inclined to believe him over the government, he wasn't his boss. Despite the title, despite that he was deputy director and the other guy was executive director, they in fact had the exact same authority. They had 50-50 authority. So despite the title difference, it wasn't his boss. Yeah. And apparently the precedent, to the extent it existed, was that each person got to control what happened on their state's line of the bridge. And so to the extent he was impacting his own side, that would have fallen within their standard operating procedure. So, so he lied to his subordinates so they'd feel all warm and fuzzy inside, and they do it. But, yeah, okay, carrying on.
What I have so far found is that the defense did ask the jury to be instructed to do just what you want. They asked the jury, they said, Judge, tell the jury that if the Port Authority granted or bestowed on the defendants the power or authority to control the property, the bridge, etc., and that they acted within the bounds of that authority, then you can't find the scheme to defraud. I think you agree with that, and the problem is the judge said, no, I won't give that instruction. Then what the judge gave as an instruction, insofar as the Court of Appeals, and we're reviewing the Court of Appeals, insofar as the Court of Appeals said, well, they gave the essence of it, this was the instruction supposed to be the essence of it. To establish a scheme to defraud, government must also prove that the scheme contemplated depriving the authority, the Port Authority, the port people, of money and property. What? That's the essence of what he didn't give? Now, I haven't read the two instructions you read, but the one that I read, I think, is the one that the Court of Appeals relied upon.
So, Your Honor.
So what do we do about that?
Well, Your Honor, I would look back at the materiality instruction I was discussing with Justice Alito.
But that isn't what the Court of Appeals relied on.
Well, Your Honor, I think if the Court of Appeals got the substance of it right and you don't agree with its particular reasoning, there's no reason to reverse, particularly when the question hasn't even been presented to this Court. This point was only really raised in the reply brief of Baroni, who didn't even petition. But let me address the authority instruction that was rejected by the district court directly. That instruction was proposed in the context primarily of an instruction on 18 U.S.C. 666, which is the more general misappropriation of federal funds statute. And the instruction on that, which appears at page 870 of the joint appendix, already itself contains a reference to authority. Both the government and the district court were quite clear in the district court, and you'll see this finding by both the Court of Appeals and the district court, that Baroni and Kelly were free to argue the authority issue. The only question was whether the jury was going to get a specific instruction on that point. And the government believed the instruction was unnecessary. It would have been a novel addition to the Third Circuit's pattern jury instruction on Section 666. And moreover, I don't know that their instruction was in fact correct, because it might have confused the jury into thinking, and this goes back to my colloquy with Justice Sotomayor, that if Baroni had some authority under some circumstances, that would exonerate.
Well, you say that the
defendants.
instruction, you thought the instruction was unnecessary. Well, that may have been the case in light of your theory at the time. But surely after your focus here on the authority point, you wouldn't make that same statement.
Well, Your Honor, I think that in retrospect it may have been better to instruct the jury somewhat more specifically on authority. I don't know that
somewhat more specifically on the central point of your argument before us today.
I don't know that their specific instruction would have accomplished it, and I don't know that the instructional issue is before the court today. But we are defending these convictions on the precise same ground that they were found to be valid by both the Court of Appeals and the District Court, which addressed the authority issue. The District Court addressed the authority issue before trial, telling the defendants they could argue it at trial. It addressed it after trial, saying it believed that authority had been proven. And then the Third Circuit addressed it. And we have been consistent throughout, and that we have never argued, to my knowledge, and I certainly haven't identified a place where we have argued, that if Baroni in fact had the authority that his counsel just claimed he had, which is to realign the lanes for any reason or no reason, that these defendants could have been convicted of fraud.
Fagan, no decision-maker has the authority to make any decision for no reason. That's a misnomer in terms. People have authority to do things only in the interest of the agency. So give me a line drawing of for reason or no reason, meaning I don't think anybody in the Port Authority, including the executive director, could on whim say, I like playing on a board. Let's change it to one lane because I just like to see a different pattern today.
So my apologies.
So give me your definition of what authorized means. If he had the ability, and when I first read your brief, it was if he had the ability to change the lanes on his own, then he had authority.
Yeah.
All right? Now, what the limits of that authority are is where I'm trying to get you.
So, Your Honor, if he were...
But it can't be no authority.
So, Your Honor, I apologize. I was simply repeating the language that the Court of Appeals itself used, which may have been a little hyperbolic. But if he were the person to whom the Port Authority entrusted the decision of whether there should be 3 lanes or 1, such that his decision under these circumstances would govern, then he had the authority. I think the evidence showed that he was not that person. Again, he had to lie about his boss.
That the fact that the executive director could overturn him doesn't prove the positive.
That's right, Your Honor. We wouldn't rely on that piece of evidence alone. Just like Justice Alito, we're not relying alone on the fact that he told a lie. We're relying on a combination of circumstances. Again, as I was saying earlier, when an idea of something to do with my organization's resources is raised to me, and my initial reaction is, how are we going to do that? And then the idea is to tell a lie that will get everyone on board with it. And then we lie about the fact that my boss is aware of it and tacitly approves of it. We avoid every legitimate process, and we conceal it from my boss. I think a reasonable jury can rationally conclude that I'm doing something that I don't have the authority to do.
Please finish.
Sorry, I was just going to say, and that's what Baroni did here. I apologize.
Can I switch? Because the statute clearly says that a scheme of deception has to, the object of it has to be to obtain property. So can we talk about that for a minute? Because if I look at this and I'm an ordinary juror, I'm thinking, the object of this deception was not to obtain property. The object was to create a traffic jam. The object was to benefit people politically. You can frame the object in lots of ways. But notwithstanding that some employee time was given over to this scheme, that was not the object of the scheme, was it, to appropriate that employee time?
Well, Your Honor, I think it was because this gets back to what I was saying to Justice Breyer earlier. This is a particular type of fraud where it's commandeering fraud, where what they're trying to do is to take property that's in the victim's hands, here the Port Authority, and convert it to their own uses. It may be that if I take a knife off a table and that doesn't belong to me and stab someone, my end goal is to stab someone, but I've still stolen the knife.
But wasn't the commandeering here completely incidental, indeed unnecessary, to the scheme being carried out? In other words, there was a little bit of time for an extra toll person actually to mitigate the problems of the traffic jam. Or there were some people running around counting cars to conceal the purpose for what they were doing. But that was not the object of the scheme.
No, Your Honor, the object of the scheme was for them to take control of real property, physical lanes accessing the George Washington Bridge, and have those lanes be allocated the way they
Okay, so
wanted.
that's a different theory. That's not the employee time and labor. That's something about, like, appropriating the George Washington Bridge. Is that right?
That
it's not appropriating the George Washington Bridge. It's reallocating lanes on the George Washington Bridge. And I would have thought that Cleveland makes clear that that's not an appropriation of property either.
Your Honor, I think it's both.
Anyone else liking Kagan absolutely beating the Solicitor General to death? Is anyone enjoying Kagan just beating this guy over and over to death, with this coming back over and over and over again? It's like she's just whacking on this guy. I'm like, yeah, it's like, man, geez, it's like it's a slog. I just, break out the billy clubs, man. Oh gosh, jeez. Oh man.
Because they needed the employee resources in order to accomplish what they were trying to do with the bridge. And if I could address Cleveland for a second. This case and Cleveland do both involve governmental decision-making, but that's where the similarities end. In Cleveland, the object of the scheme was to obtain a license under a regulatory scheme that had no private analog whatsoever. The court rejected every private analog the government offered for it, and the license wasn't property in the government's hands. Here you're talking about real property, physical lanes, and who can access those lanes. And access rights to physical property are quintessential forms of private property, probably one of the oldest forms of property we have. And then you have the employee resources necessary to reallocate the lanes, which I think even they acknowledge are property under the fraud statute. They acknowledge that if you send painters to paint the mayor's house, that's going to be property fraud because you're taking the employee services.
Well, that's because the object of the scheme is to use the employee labor to get your house painted. But I don't think that you can say the same thing here.
Your Honor,
you were not using the employee labor to create the traffic jam.
They are using the employee labor as if it were theirs, not as if it were something that the Port Authority gets to use. So again, in the private context, if I were to impersonate the boss and start ordering around the company jet,
these analogies are not happening. In the space of two sentences, he went from having my sympathy to losing my sympathy. So when he said they're using employee labor as if it was theirs, not something the Port Authority gets to use, the thought that went through my mind is, that's actually a pretty good point. As Kagan pointed out, you have to do things that are in the best interest of the agency, the best interest of the entity, and here you're using it not for that purpose, but rather for political retribution purposes. So, the agency has no interest in political retribution. And therefore, you're using it as if it was theirs, not something government gets used. It's like, okay, I kind of buy that argument. And then he immediately just takes the life out of me by talking about impersonating the boss and ordering around the company jet. I'm like, that's not at all the same thing. At least to my mind, it's not the same thing. So you had like a really good argument, and then you try to analogize it to something which, to me, doesn't analogize. And it's just like you're just destroying your argument. Because I'm like, okay, you had something, and then I'm like, why? What, a boss and ordering company chat? I mean, no one in their right mind thinks that that's okay. That's not what we're talking about. it's like comparing the most, I won't say necessarily the most trivial thing. It's comparing a relatively trivial thing to like the most extreme example and saying, well, they're both equally the same. Taking this thing that's, relatively banal in the grand scheme, compare it to like the most blatant possible offense and say, oh, they're in the same category. It's like, it's not working. Matthew says, if they kick it down for improper jury instructions, don't see how they can't recharge him. Yeah, I think they can recharge. I think they could bring the case again. I don't think double jeopardy is a problem here. If they kill it for the jury instructions. So, yeah, let's carry on.
The company jet and probably the pilot's time as well.
Yeah, you picked an example that is easy for you. I mean, the
that's
example
what I just
that's
said,
hard
right?
For you, I think.
That's what I just said. Roberts and I were just like saying the same thing. Yeah, Roberts is saying basically the same thing. Yeah, you just picked an example. It's easy for you. You picked the most extreme example. Is that a straw man? It's something. It's like, you picked an example that's trivial versus this, which is a lot more nuanced. And you're killing me, Smalls.
Tell the employee to pick up the phone and call somebody and say this. That's a bad thing. And then immediately you say, okay, it's property fraud because I've used the employee has used the telephone, or I've used the 4 minutes of that employee's time necessary to convey the message. Sure. Your theory would say that that's taking of property, so it's covered by the fraud statutes.
We wouldn't, Your Honor, and I'm actually glad to have a chance to make this perfectly clear, and this gets back to Justice Kagan's question as well. Incidental uses of property that are not the object of the scheme are not going to be sufficient for property fraud. And I think the easiest place to look for that is this Court's decision in Loughran, which involved bank fraud. And the Court said there that if you tell a lie and the object of your lie is to obtain money, it's not bank fraud simply because, unrelated to your lie, you didn't really care how the money came to you. The money comes to you in the form of a check, which is bank property, as opposed to in the form of cash, which isn't. If someone tells a lie and the object is to obtain a license from the state of Louisiana to operate a video poker machine, which is not property, they're not committing property fraud just because some employee needs to spend some time processing the license.
Well, here
That's
the object of the scheme was not to commandeer lanes on the bridge. The object was to cause a traffic jam in Fort Lee, and if they could have done it some other way, they would have done it some other way. The use of the traffic, altering the traffic lane configuration was just the incidental means of achieving the objective.
I don't think that's right, Your Honor. The lie they told to the Port Authority to get the Port Authority resources was a lie they told in order to get those resources. The causing of the traffic jam was what they wanted to accomplish with those resources. If I tell a lie to get access to the company jet,
no one cares about the company jet.
It may be that my goal is to take it on a vacation trip to Macau, but that's not the object of the scheme as far as the fraud's concerned and the victim of the fraud. Thank you.
Thank you, counsel. 2 minutes, Mr. Roth.
Thank you. Your Honor, the federal property fraud statute prohibits schemes to obtain property. And the government's theory of property here, as I think we just heard, is that the officials, by making this decision about lane alignment, commandeered the control over the George Washington Bridge. That is exactly the type of regulatory control that Cleveland said is not property. Cleveland referred to the intangible rights of allocation, exclusion, and control. And the sovereign's intangible rights of allocation, exclusion, and control are not property for purposes of this statute. And therefore, if what the officials did was use deceit to influence the exercise of those rights, they have not obtained property from the Port Authority.
I mean, to me, that's like dispositive. It's not even like the jury instruction problem at this point. It's just that even with the correct jury instruction, it doesn't fly. Because what they took isn't property as that term has been defined by prior case law, right? We're not interpreting this in a vacuum. We're interpreting this in the light of prior cases, including this case called Cleveland, and said, well, these kinds of intangibles don't count as property. Okay, they don't count as property. Fine. And therefore, all they took was intangibles. So it's not property because a prior case said so. I'm like, I'm done. I mean, I don't even have to get into anything else. There's no property here. It just doesn't exist. So like, as far as me, I'm like, that's a dispositive argument. So
if that is not correct, then everything an official does falls within the scope of this statute, and the only question that is open is, was there some deceit involved? And if that is right, I think the chilling effect on honest public servants is going to be severe.
Mr. Roth, you responded to one half of their theory. Like, one half of their theory is the allocation of lanes,
yes,
and the other half is the employee time.
Yes.
So what's your response to that?
My response to that, well, it's actually what he said at the end, which is that the incidental costs of a decision are not its object, and it's what Your Honor asked in the earlier question. The implementation of the regulatory decision is going to use some public resources. That cannot possibly change the result, or else Cleveland is a complete dead letter.
Why do you call it incidental? I mean, it was essential to the scheme.
Because it's incidental, Your Honor, in that it was the implementation cost. It flowed as a result of the regulatory decision. So the regulatory decision was to realign the lanes. That required some employee time in terms of taking tolls and studying the traffic effect. But that was not the object. That was how it got done.
What if it cost $1 million? Would it be incidental?
No. Yes, Your Honor. It would still be incidental. It's not a de minimis test. It's a question of what is the object.
Thank you, counsel. The case is submitted.
Well, I mean, for me, I think the appellant has the better argument. So my only question is, reverse by what count? Am I going to go say 9-0 to reverse, or do I think like Kavanaugh is so statist or something that he's going to vote to like affirm? And if Kavanaugh votes to affirm, does anyone else vote to affirm? Not really that I'm seeing. Yeah, not really that I'm saying. This is Gorsuch's line of thinking for sure. So he's going to be in the majority with everyone else. Roberts is definitely going to be in the majority. Yeah, I don't know. So what am I thinking? Am I thinking 8-1 or am I thinking 9-0 to reverse? 8-1 or 9-0 to reverse. Either reverse with vacate or just straight reverse. The only reason you'd vacate is if you want to fix the jury instruction. If you think there's no property here because there's no property here, then you just vacate and say, well, the court below got the law wrong. There's just no property because of our prior decision in Cleveland, so reverse. So I'm going to say no vacate. I'm going to say this is not vacated, or I'm not remanded. This can be vacated because it's a criminal conviction. So it'd be reversed, vacate, and remand for, decisions consistent with, in other words, letting them out, but like not for another trial. So I think these guys are getting out of jail, assuming they are in jail, and there's not going to be another trial. That's my working assumption. So whether it takes the form of reverse vacate, reverse whatever, I don't know. 8-1 or 9-0. What do I think? I'm going to say 9-0 to reverse. I think Kavanaugh is not going to stick his neck out for this one. So I'm going to say 9-0 to reverse. So that is my prediction. Matthew, couldn't they recharge? Well, not if the crime doesn't exist, because there's no property. Not if they could if they say, well, the question is there enough evidence? And we know, because there's been a jury finding, right? So it's like, is there enough evidence to potentially find the guy guilty of the statute based on how we're going to write it, right? Because we're gonna change the wording of the statute. So like, is there enough evidence that could lead to a guilty finding using that language? If the answer to the question is yes, then sure, send it back to another jury. Be like, here's the right law, go give it another shot. But if the answer is no, if the answer is, well, given a correct interpretation of the statute, there's not enough facts here, then what do you send it back for? You wouldn't charge again because, no matter what the jury finds, you can't convict them because, well, it's just not there. So now I think only two of the counts are being challenged here at the Supreme Court. So maybe these guys don't get out of jail. Maybe they just have their time reduced substantially. And there's some other things that they were convicted of. So possibly. So that's where we are. Yeah. So I'm going to say 9-0 for my fantasy Supreme Court prediction. 9-0 to reverse. And the government's argument was muddled, and it was also foreclosed by precedent. It was, no, it's not flying. Also, I don't know if they've been found guilty of any state charges. Maybe the state of New Jersey also sentenced them separately, so they would still have to do New Jersey time in addition to federal time. So I don't know. Maybe that's true too. So I don't know. Yeah. So. Yeah. So. Well, apparently they didn't charge 666 too. They charged A1A. So I don't think they can charge a different section than they charged last time. So I don't think they can. I don't think they're going to bring these charges back. I think these charges are going away. All right, that's my best prediction. If you liked this stream, for the 31 of you who are watching this, and you have not already done so, if you would be so kind as to give me a like, it encourages me to keep going. And as always, I appreciate you checking out my channel and checking out what I'm doing here. Hopefully you're having a good time. I'm having a good time, and really appreciate you being with me as we do another Supreme Court React. This was a very interesting case. Came into it with my open mind, and I'm leaving with a feeling one way or the other. So I think we've done a good review of this. It was educational for me, and I hope it was educational for you. We learned a lot more about a lot of prior case law, and it was a really good time. So until next time, my friends, this has been Uncivil Law. I hope you're well, and until later, cheers and goodbye.